concrete suggestion here is that the information should be included in the next report, which is due so soon from now.
Thank you very much, Mr. Flinterman. The next speaker is Mr. Cheny.
Thank you. I fully agree with everything said by Mr. Flinterman. I wanted to raise the point of qualification with respect to the first recommendation. I know that these are always issues that we sometimes grapple with, because when you have categories, there are always cases that fall in between. But at least the evaluation that we give does seem to indicate that the state did provide data which reflects some movement in the direction that we have indicated with respect to tackling police brutality. And I was wondering whether, in light of this, a B2 qualification wouldn't be more adequate than a C1 qualification. Thank you.
Okay, there are no other speakers on the list, so I'll hand the floor over to Mr. Salvioli again.
Thank you very much, sir. And thank you, Mr. Cheny. As has happened on numerous occasions, the categories overlap the ratings, and so I'm not opposed necessarily to following Mr. Cheny's proposal. I think, based on the information before us, the C1 rating would be correct. But if everybody else prefers B2, then I don't have any problem with changing to that recommendation.
Ms. Albertotti, you have the floor.
Thank you, Mr. Chair. We had a discussion about this very same issue. In the end, we decided C1 for the following reasons. There had been some steps with regard to the investigation. However, with respect to the remaining issues, there had not been any kind of information, especially with respect to the independent oversight mechanism that was also part of the recommendation. And this, in the end, led us to propose a C1. But given the discussion among us, I don't see a problem if Mr. Cheny insists on the B2 to change that.
Thank you very much. Are any other speakers? There are no other speakers on the list. My understanding is that the C1 is proposed for the reason, and thank you very much for both for Ms. Seibert and Ms. Salvioli for explanations. The State Party basically repeats what it has provided in the state report, in its report, and that led to the. My understanding that led to the evaluation. However, if rapporteurs do not object and there are no other comments on this issue, I assume that the committee is ready to accept the suggestion made by Mr. Cheny. Okay, this is the case. So your suggestion is accepted. Thank you very much, Mr. Cheny. And now we move forward. Floor back to you, Mr. Salvioli.
Gracias, señor.
Thank you, sir. Mr. Flinterman had made a request, and Mr. Cheny regarding requesting information. We can do two different things here. Either we request information from the State Party, as reflected here, or we consider the procedure closed and ask them to submit information in the next report. We can't do both, because that would be contradictory if we were simultaneously to request information in both forms. Since the report is to be submitted in about a year's time, and moreover, we have 2 sessions in the meantime, we thought it was too soon to complete the follow-up process, and so for that reason, we thought we could continue the process, the procedure. But if the committee feels we should suspend the follow-up and we just ask for the information for the next report, then we could do that. But we must decide for one or the other. We can't ask them for both. Say they submit additional information in very short periods of time and then more information in the next report. So that would be contradictory. So the committee must decide which course to follow. Thank you.
Okay, thank you very much, Mr. Salvioli. Mr. Flinterman is seeking floor again. I hand over the floor to you.
Very briefly, Mr. Chairman, my preference would be indeed to suspend the follow-up procedure for Turkmenistan and to ask the state party to include the information which is requested in its next periodic report. And my reason for that is that I fear that if we ask additional information on the questions raised in the follow-up procedure, that might have a negative impact on the report that has to be submitted by the state party. And since the report is due on the 29th of July, I think it would be proper in this case to ask for the information to be included in the next report. That will help, I think, also expedite our own work.
Mr. Flinderman, thank you very much for your additional explanations. We're talking about, we are discussing Bulgaria evaluation regarding the, right? No, you mentioned Turkmenistan, so that brought some confusion here.
Turkmenistan have the same problem, Mr. Chairman,
Okay.
so my apologies.
Okay, so if, Mr. Salvioli, please, you have the floor.
Muchas gracias.
Thank you. What we usually do is not to suspend the procedure at such an early stage when we still have a couple of sessions during which we can analyze follow-up. But I'm not sold on either option necessarily. So we've just presented the draft as you see it before you.
Mr. Salvioli, the next speaker is Mr. Yusawa. Mr. Yusawa, you have the floor. No. Okay, Mr. Yusawa is not seeking the floor. Are there any other comments or questions? Well, we have to make a decision on both issues, on the evaluation and on whether we close it, whether we suspend the communication with the state party. Well, I understand the concern of Mr. Salvioli that the next report is due in July of 2015, and that would mean that we will be considering the report even a few years later. And that implies that we will have a lot of time in front of us. And I understand again the rationale, the reasoning behind requesting the additional information right now, unless Mr. Flinterman would insist on his suggestion, or if there are any other members who would also like to express their views on this issue. Mr. Flinterman, you are taking the floor.
Well, I'm not pressing the point, but I take it that if the state party would live up to the request by the committee to submit its periodic report by 2015, 29th of July 2015, it has started, or it will start very soon from now, the preparation of that report. And it would seem to me to be very practical that in the course of the preparation of its periodic report, it could also answer the questions in the follow-up procedure. But on the other hand, I see the rationale explained by Mr. Salvioli, and since my suggestion does not seem to find any support of any other member of the committee, I'm of course most willing to withdraw my suggestion, although I continue to think that it is a wise suggestion.
Thank you very much, Mr. Flinteman. There is no doubt that your suggestions are, this one is wise, and they're always wise, and we'll be happy to follow them. Mr. Shani is taking the floor. You have a floor, sir.
Thank you. Without delving on this point too much, because we already have, I think we still have 8 more countries to cover. I think it would be wise, not now perhaps, but for the rapporteurs to consider this point in future cases and determine on a case-by-case basis whether there are special reasons that require us to maintain a follow-up process when a report is impending. I think I'm not sure that we are at the moment that we can make these decisions on a case-by-case basis for each of the recommendation. But I think going forward, I think there is a lot of sense in what Mr. Flinterman said. We don't want to overburden states with endless number of reports when they are already in the process of reporting. But then there may be some issues on which we wouldn't want to lose our ability to closely monitor them through this process. So I think this is something that we would need to take up in the future. Thank you.
Thank you very much, Mr. Shani. Well, I repeat, again, I understand the rationale behind your suggestion, and they seem quite reasonable. Again, the suggestion is reasonable and justified. My impression is that asking additional information may even help the state party to prepare better for the report while providing information. So we could really go both ways. And if it is a decision of the committee, my understanding of the decision of the committee is to keep with the draft. And the final word, again, back to the rapporteur regarding the evaluation and the final sum up. Let me give you a floor to sum up the discussion on the issue.
Gracias, señor.
Thank you, sir. I do want to be brief because we not only have many countries still to consider, but we also have individual communications, and it all has to be done during this session. I believe I've been persuaded by Mr. Flinterman's arguments now that I've heard him again and that we've heard from Mr. Shani, and I'm open to being persuaded to change my position. Perhaps we can follow the usual practice, but we certainly take note of what Mr. Flinterman and Mr. Shani have said. And I assure you, sir, that for the next report, we will bear this situation in mind. I'd like to very warmly thank Mr. Flinterman and Mr. Shani for this discussion, which I think is very useful for the whole follow-up procedure. Thank you.
Thank you very much, Mr. Salvioli. Have we decided about the evaluation on the suggestion of Mr. Shani was accepted? That's okay.
Yes, absolutely.
Thank you very much, Mr. Salvioli, and to all of the members who made comments on the issue. They were indeed very helpful. We're moving to the next state report, state party, and this is Turkmenistan. And I hand the floor back to Mr. Salvioli.
Gracias, señor presidente.
Thank you, Mr. Chairman. Turkmenistan. We had focused on torture and essentially the lack of appropriate codification of the crime of torture in the context of our covenant, and also independent mechanisms to oversee and conduct investigations in case of allegations of torture. The state party has given us a reply prior to the observations, stating that on the 4th of August 2012, an amended criminal code was came into force that criminalizes torture. And that, of course, is important. The visits by the Red Cross 2 prisons, with partially satisfactory reply. They were able to enter some sites, others they were not permitted to do so. So we've divided the evaluation for each subparagraph. So for the first, we have a B2 because the new Article 1821 was implemented. What we want to do now is how it's applied, whether this new article really is serving to bring criminal proceedings against those involved in torture. And then we have C2, because we have a repetition of the information. And the next subparagraph also, both C2. Repeating the recommendation to the state. The other paragraph, the next one, refers also to independence of the judiciary. The committee will remember that we'd suggested to the state or identified some difficulties regarding the Interior Ministry's mode of operation. It was being reformed. So we were concerned about the independence of the judiciary. We asked them about that, but they didn't give us any additional information. We do have some information from NGOs, however. But since the state party didn't provide anything, we suggested D2. That is, the state did not provide a response to this issue, D2. The next paragraph relates to freedom of expression and protection of journalists and human rights defenders. It's paragraph 18. Now, I note this because in the Spanish version, it appears as paragraph 8, so that needs to be corrected. I don't know whether in the other languages it's correct, but the Secretariat might note that this is paragraph 18 of our concluding observations on Turkmenistan, not paragraph 8 as appears in the Spanish version. And so we talked about protection of journalists and human rights defenders in general, and then we'd raised some specific concerns regarding restrictions on the exercise of freedom of expression, its compatibility with the covenant, and we'd also talked about the need of ensuring access to websites and the need to protect journalists and human rights defenders. So the state gave us some new information on the Media Act that governs everything to do with freedom of expression and other standards adopted through presidential decision regarding owners of newspapers and magazines. The state continues to have monopoly of information through certain mechanisms to exercise control. That we were told that by an NGO. And on the remaining issues, we received no information. So overall, C1. So we note the new Media Act. We asked for information regarding its implementation, and we request information on measures adopted to disseminate information free from the risk of intimidation and harassment. We suggest that the state be sent a reminder containing the committee's analysis. So that's the evaluation I would suggest for Turkmenistan. Thank you.
Thank you very much, Mr. Savioli. Now floor is open for the questions and comments, and the first speaker on my list is Mr. Bouzid. You have a floor.
شكرا سيد الرئيس. لي سؤال للسيد
Thank you very much. I have a question for Mr. Salvioli. The decision was to send a letter to the state asking for additional information. The next periodic report is 30th March 2015. So we need to coordinate follow-up on this matter. If we could just clarify that, please.
Señor presidente, muchas gracias.
Thank you, sir. Mr. Bozert is entirely correct. And thank you for raising this. We can make a change, not to our recommendation, but the last part of our decision say that the state should submit the information in the next periodic report in March 2015.
Yo acepto.
I accept that suggestion by Mr. Bouzid. Thank you.
Well, thank you very much. Thank you very much to Mr. Bouzid and to the rapporteur as well. Secretariat is taking the floor for some clarification, so I hand over the floor to Ms. Santana.
Thank you, Mr. Chair. I just wanted to draw your attention to the note by the Human Rights Committee on the procedure for follow-up to conclude observations, which was adopted in the 108th session. And paragraph 25 established the reason for discontinuation. Paragraph 25, letter C, says that the follow-up process can be discontinued under the following circumstances. And letter C established that when the deadline of the next periodic reports is within 6 months after the adoption of the follow-up progress report of the Special Rapporteur. In this case, the follow-up questions that have not been replied to by the state party will be automatically included in the list of issues. Thank you very much.
Thank you very much for the Secretariat. It's quite a useful information. I was trying to calculate now if we're within the 6 months or beyond it, and I think we are somewhere on the edge, in a gray zone, I would say. It's what is the date of the next? So it's
maybe Mr. Salvioli would like.
I think the rapporteur is taking the floor, so I hand over to him. You have the floor.
Gracias, presidente. Faltan 5.
There are 5 months. I think Mr. Bouzid's right. Mr. Bouzid is right, I believe, and we should ask the state party to include this information in the next report. Thank you.
Thank you very much, Mr. Salvioli, and personally, I would agree with you as well. But Madame Chenet is taking the floor. You have the floor, Madame.
Very briefly, Mr. Chairman, this proves that the guideline that has just been read should contain not only the 6-month limit, but 6 months or the next session of the committee if it does not fall within that 6 months. Thank you. Falls within the 6 months.
Thank you very much, Madam Chairman. Are there any other members wishing to make a comment or to have questions? Then I would suggest that we move forward, taking into account suggestions made by Mr. Bouzid and Madame Chenet and accepted by the rapporteur. Thank you very much, and you have the floor.
Muchas gracias.
Thank you very much, Mr. Chairman. I'm grateful also to colleagues for their queries and comments. The next state is Guatemala, and on Guatemala, the first recommendation is linked to a matter which is crucial, namely historical memory and the investigation of the widespread human rights violations and reparations that are owed to victims. We had asked for information on measures, reparation measures, and more specifically on the rehabilitation measures and guarantees of non-repetition or non-reoccurrence, in addition to the reparation and compensation. The state gave us information which they had already given us during the New York session we had with them when we discussed matters with the state party. And so the state gives us some additional information on reparations. More concretely, they have broken down the types of reparations they have provided for victims. We also have information from non-governmental organizations. We take note, of course, of these this progress made, but we are going to ask for more information. More information on those cases that have been registered with the compensation program, the number of applications for compensation since 2013. We don't have that in the information provided to us. There's also one aspect pertaining to the building of housing, which as a reparation measure is important, but we don't know how effective that measure has been. It would appear that obstacles have lie in the way to the implementation of this reparation, and also the budget appropriated for this program, because without a budget, without money, you can't provide the appropriate compensation. So we've noted some progress, but not something that we could be entirely satisfied with. So the draft before you, that we're presenting to you, proposes that we give a rating of B2. With regards to the next follow-up issue, this has to do with the implementation of an effective mechanism for the investigation of the whereabouts of disappeared persons. Very difficult, sensitive, painful issue for this country, Guatemala. We have received a reply from the state party, which candidly is slightly disappointing. They tell us that they've put forward the project or the bill, but it's the legislative branch of government that is now in charge of dealing with it. But the problem is the legislative branch of government is part of the government, and therefore the state party needs to bring its legislative branch of government in line. Now, in the current legislature, plan is for this bill to be enacted. That's why we can be hopeful. Therefore, we propose to give this issue a B2 rating. In other words, we need to continue to insist that this bill, which is currently before the Parliament, we need to insist on it to be enacted in this particular term. The next issue has to do with protection of human rights defenders. We had asked the state party to give us specific information on the public recognition of the role performed by human rights defenders and the measures taken to prosecute and punish those persons who commit human rights violations against human rights defenders. We'd also asked them to tell us what process they had set up for the handling of complaints of human rights violations against human rights defenders. We asked about the information about the unit on human rights defenders. The state gave us some information on this. The state has also given us details as to how the attack analysis unit functions, and they tell us that they're going to provide more human resources for that particular centre. The executive branch of government is also working a lot more specifically with the government on this, and something which is extremely valuable, I believe, and that is that the state has set up a mechanism for early response. So this is an institutionalized mechanism to handle with complaints submitted by human rights defenders because when they have been subjected to attacks. Now, a number of measures have therefore been taken, and this year, in the current year, 2014, 2014 has been the year during which the most attacks against human rights defenders have been registered or observed. And this is something we should also bear in mind when we rate the country, we should take into account not only what the state tells us, but also what's happening on the ground. So the committee will find that here we have 4 different levels or assessments to give in the light of this. D1, first of all, for the public recognition of the contribution of human rights defenders, because on this the state has not made progress. So D1 for that. C1 rating on the measures taken to defend human rights defenders. B2 on the early response mechanism to see how the state is responding or to give prompt and timely response to complaints about attacks on human rights defenders. And C1 on the operation of the body, the Office for Analysis of Attacks on Human Rights Defenders, because its makeup is not stable yet, and this lack of stability means that it cannot operate entirely effectively. Thank you very much, Mr. Chairman.
Thank you very much, Mr. Salvioli. And now floor is open to the questions. The first speaker is Mr. Flitterman. You have a floor.
I have a very short question, Mr. Chairman. I agree with the analysis of the rapporteurs. My short question is whether the letter reflecting the committee's analysis is indicating a specific date by which a reply of the state party is expected. That's my simple question.
Thank you very much. If there are no other speakers, then I invite Mr. Salvioli to respond.
Sí, claro.
Yes, of course, of course. We always ask the state to give information by a certain deadline. The problem is we're waiting for the committee to tell us or to adopt the report before we can draft the appropriate letter. Yes, but of course, you are right.
Okay, thank you very much. So the letter will be drafted with a specific information in it. Any other speakers? Then that would mean that we'll conclude it, consideration of this state party, and we're now moving to the next one, which is Portugal, and I hand the floor back to Mr. Salvioli.
Muchas gracias.
Thank you very much, Mr. Chairman. On Portugal, the first aspect we had asked the state to respond to had to do with persons on pre-trial detention and the length of time they were detained. As occurs in many countries, the persons who are in pre-trial detention or on remand can be detained or sometimes detained with people who are already convicted. The state has given us a lot of information on this particular issue and on measures that are being taken and legislative amendments that they've brought to reduce the number of persons who are on remand or on pre-trial custody. So the assessment on this proposed is B2. In other words, we've taken note of the fact that a number of steps have been taken, and we asked the state party for more specific information to see how these measures or these new sets of rules and regulations have been implemented to reduce the number of persons on remand. Paragraph 11 of the concluding observations is linked to the previous one, and it has to do with the prison overcrowding in the country. The state on this particular point speaks to us about the implementation of a number of plans. We had concretely spoken to them about those services that need to be provided to those persons who have HIV/AIDS and hepatitis C. We'd asked them specifically on that, and the state responds to that particular query we put to them, and they tell us how they now register detainees, together with what the Ombudsman does, who is empowered to visit prisons regularly and who does so. So we propose a B1 rating on the measures taken for overcrowding in prisons, and we ask for additional information. We propose B2 rating for access to medicines and the protection of the human rights of persons who've got HIV, AIDS and hepatitis C, because the answer of the state party is much more general, much too general. We wanted more specific information, and we propose B1 rating for the work that has been carried out by the Ombudsman and the visits to penitentiary centres. So we ask for more information on that. The third concluding observation issue that we looked at has to do with domestic violence and how domestic violence allegations are investigated and prosecuted in the country. The State Party tells us that it has implemented a number of national plans to fight against domestic violence and that it has enlarged laws to cover violence perpetrated in certain spheres to be categorized as domestic violence when this violence is not actually perpetrated in the home. So it's enlarged its domestic violence coverage. It has given us some information as to how they specifically address this issue through specialized units to investigate and prosecute allegations of domestic violence. And they've told us about a number of measures they've taken to rehabilitate victims of domestic violence. The information they've given us on these three subparagraphs is extremely valuable, and therefore for these three we propose a rating of B1 and asking for more information in each of those three subparagraphs. We, of course, are telling the State Party that they should reflect the position of the committee through a letter. Thank you very much, Mr. Chairman.
Thank you very much, Mr. Salvioli. And now floor is open for the questions and comments. Mr. Filterman, you have the floor.
Thank you, Mr. Chairman. I've noted throughout this report how difficult it is for any state to get an A. And I realize, of course, that professors are not very much inclined to give the highest grade to anyone. But in this particular case, in Portugal, it seems that the State Party has, I think, very much in a very positive way reacted to the follow-up procedure, given extensive information. And my inclination would have been reading, for example, the information given in response to the concern in paragraph 12 that substantive action has been taken. We may need a little bit more information, but there that an A would have been appropriate, because I'm fearing a situation in which we continue the follow-up procedure. Of course, it's always possible to ask for more information, but sometimes there should be an end to asking more detailed information, and that is the reason that I'm suggesting to the rapporteurs to reconsider the evaluation on the third issue.
Thank you very much, Mr. Flinteman. Any other speakers? Mr. Cheny is seeking the floor. You have the floor.
Thank you. I had exactly the same observation to make as Mr. Flinterman. I thought that, and I want perhaps to add just an additional reason, not just the professors being very hard on the students, but also the recommendation is not about attainment of results. It's about means. It's taking steps to combat. So while we would want to see in the long run what would have been the impact of these policies, I think that the next periodic report would be the natural forum to assess the effectiveness of the programs that have been introduced and not the follow-up procedures. So I think on all three paragraph 12 related recommendations, I think the state has taken significant measures to implement and the report, and I think there is not much that we can ask from it at this stage. Thank you.
Thank you very much, Mr. Cheny. Any other speaker? Madam Ajudina, and then Mr. Kelly.
Thank you, Chair. Just to support the views of the last two speakers, thank you very much. I agree with them.
Thank you very much, Madam. Mr. Kelly.
Thank you. I also support that approach. Thank you.
Thank you very much. So, and I would like to thank, before handing floor to Mr. Salvioli, I want to thank Mr. Flinterman, who again proved that his suggestions are indeed wise, and also Mr. Shani and others proved that professors sometimes give A. It's very difficult, but sometimes you get it. But Mr. Salvioli, floor is back to you.
Muchas gracias, señor presidente.
Thank you very much, Mr. Chairman. Ms. Zabet-4 and I are teachers, professors, so this applies to us as well. And we are indeed very drastic, but we are professors who are able to listen. And in that respect, we've listened to the opinions of the 4 colleagues, and they have convinced us that we can indeed change the rating. But just allow me explain why we opted for B in this particular case. The next State Parties report will be October 2018. So perhaps in the meantime we might receive additional information, but we will follow the advice of colleagues. Thank you very much.
Thank you very much, Mr. Salvioli. Unless you want to add anything to this particular state party, I think the suggestion is accepted. And unless you want to add anything, then we'll move to the next state party.
Gracias.
Thank you, Mr. Chairman. The next state party is Turkey. The first recommendation has to do with acts of discrimination and violence against LGBTI population. This was a concern voiced by the committee to the state party. The state party gives us information, but they gave us the same information as the information they gave us when we had the interactive dialogue with them when they submitted their report to us. And that's all they give us. So the proposal is to give this recommendation a C2 rating, and this means that the state party must take effective measures, and we want more information, more specific information about aspects that they've worked on. In other words, we want them to say to them that they will not tolerate any stigmatization of persons because of their sexual orientation or their gender, and we need them to tell us how they are prosecuting persons who are guilty of discrimination or who are guilty of attacks on LGBTI persons, and what social awareness-raising measures they are taking. And in that respect, the state has told us nothing. So the proposal is to give this recommendation a C2 rating. Paragraph 13 of the concluding observations is linked to the awful practice of honour killings. And the state party in that respect on honour killings tells us that it abolished the de facto reduction of sentences for honour killings. And but apart from that, we're not told anything new. There is just a repetition from them of the information that they had already given us in the past. They don't give us any information as to honour killings and statistics, specific statistics on these. They don't tell us about any dissemination measures either. So for the two aspects, the first two aspects, we've given a C2 rating, and for the third one, we've given a D1 rating. On the conscientious objection regulations, that's conscientious objection to compulsory military service, this has been a recommendation from the committee in its concluding observations, and I would just like to recall also that there are individual communications or cases for which or on which the committee has found that there is that the state is internationally responsible under Article 18 of the Covenant, and in that respect the state has not given us a satisfactory answer either. They tell us that they have, in fact, no plan to change their laws on military service and conscientious objection. So we propose to give an E rating, the lowest grade, given that the state is telling us that it is not going to follow the committee's recommendation. And that would be our proposal for Turkey. Thank you, Mr. Chairman.
Thank you very much, Mr. Salvioli. Now the floor is open for the questions and comments, if there are any. If there are no any questions, then I would prefer to, then we would probably should move to the next state party. The floor back to you.
Muchas gracias.
Thank Thank you. Moving on to Paraguay, therefore. I would like to add to the information contained here the fact that we met with the representatives of Paraguay during this session, this current session, with Ms. Seibert IV. We met with a representative of Paraguay who took note of our concerns. The first of the paragraphs for which we asked information to the state party has to do with compensation for human rights violations perpetrated during the dictatorship of General Estroño. The state party provides some information on this in terms of reparations awarded as well as measures taken to identify disappeared persons. So we propose that we give this recommendation a C1 rating because it is not complete, far from complete. The state gives us some information, but we still need to be told how they are proceeding with regards to pending prosecutions or investigations of human rights violations, and also the cases that were brought before 2013, what is of them, and we need information on reparation awarded to victims also. With regards to the investigation of the whereabouts of disappeared persons, also on that particular point, we decide to award a C1 rate because the INABI, which is the Office of the Ombudsman, the INABI is the body carrying out these investigations, does not have enough funds to perform its duties impartially and independently. Paragraph 14 is the next concluding observation. Subject to follow-up, is linked to a significant issue, a major problem, and I'm referring here to the the neighbourhood watch committees. They are self-defense committees in two particular towns of Paraguay or areas of Paraguay, and who work outside of the margin of the law, well, on the margin of the law, and with impunity, therefore. And we're not given any information from the state party in that respect, and they appear not to have taken any new measures on the review and functioning of the neighbourhood watch committees. So we propose to give this paragraph a C2 rating. And on paragraph 23, these are linked to the Curuguati massacres that have had serious political consequences. We had a very intense debate with the state party and the state party gives us some information on these events, but they appear not to be taking seriously their duty to investigate those persons who are responsible for the massacre, but rather they're focusing on prosecuting the people who are involved in the demonstration rather than the people who are involved in repressing the demonstration. So some progress has been made, but really not much has been done. For those reasons, the rating suggested is a B2 rating. And we're also suggesting that that we put the analysis of the committee in a letter to the state party. Thank you very much, Mr. Chairman.
Thank you very much, Ms. Salvioli. There are speakers wishing to intervene, and the first speaker is Mr. Chani. Mr. Chani, you have the floor.
Thank you, Mr. Chair. I would like to make a rather similar comment to the one I made before concerning Bulgaria, I think, with respect to the first recommendation here on Paraguay, the paragraph 8 recommendation, the C1 ranking for the first recommendation. And the question is whether, in light of the fact that the state does report that some measures have been taken, that the criminal trial court number 5 started, and that the judiciary has asked for more information, and some changes have been made to the law, isn't a B2 recommendation more suitable under the circumstances? Thank you.
Thank you very much, Mr. Chani. No other speakers, so I would like to hand floor back to Mr. Salvioli. if he wishes to comment.
Thank you very much, Mr. Chairman. I would keep C1 because we have NGO information according to which, they are very critical of the lack of progress made on this particular matter. In the meeting we had with the delegate from the mission of Paraguay a week and a half ago, we asked her specifically to comment on this issue, and she wasn't able to give us any additional information that would enable us to ascertain that they are taking measures beyond what we have read here. So I would prefer to keep the C1 rating, but of course I'm in the hands of the committee if the committee wishes to change that rating.
Thank you very much, Ms. Salvioli. Anybody else wishing to wishes to intervene on that issue? Ms. Mangiadina, you have a floor.
Thank you, Mr. Chair. I also feel that the rating of B2 to paragraph 23 is a bit stringent. We could do with B1 because quite a few steps have been taken by the state party, the criminal proceedings, including some results that have come out of those proceedings, and as indicated in the rest of the paragraph by the state party in its replies. Thank you.
Thank you very much, Ms. Mangiadina. Ms. Salvioli.
Muchas gracias.
I'd like to thank Ms. Mangiadina very much, and perhaps this reflects this issue, this problem that we need to draft short reports in which we can't really explain the full situation. The state is carrying out investigations and prosecutions, but it's not trying the persons who are responsible for the massacre. They are trying the peasants, the farmers, who were demonstrating. So the trials for human rights violations are not progressing. Progress has been made for the prosecutions of the persons who were demonstrating in the streets and who were the subject of the human rights violations, the victims of human rights violations. So the public prosecutor's office has not demonstrated in any way that is leading investigations to bring to trial the authors of human rights violations. And when we talked about what rating we should give this paragraph, my intention was rather to give a lower grade than the one we have finally adopted. But I'd prefer to keep the one that is in the draft. So thank you very much, and thank you very much, Ms. Mangiadina, for that issue, because your question enables me to clarify something which in the report might not have been as clear as it could.
Thank you very much, Ms. Salvioli. Next speaker is Mr. Rodriguez-Gracia.
On this particular point, yes. I think that Mr. Salvioli was clear. I know this issue very well, the Kurubati investigation and the whole context of the Kurubati massacre. There is a victimization because many of the deceased were the demonstrators, and they are being accused of criminal acts. So, in the context of this investigation, there are no prosecuted persons on the side of the state. That's the problem. So, there is impunity there. So, I know this case very well.
Thank you very much, Mr. Rodriguez-Gracia. I think that Deputy Rapporteur, Ms. Salvatore, also in agreement with the evaluation suggested in the draft. Anybody else wishes to intervene? Mr. Chani, are you satisfied with the answers received, or you would like to continue to press the issue?
I do not insist on my position being accepted every time. Thank you.
Thank you very much, Mr. Chani. And Ms. Mangiadina, are you happy with the answers? Thank you, and thank you very much to the rapporteur. Now we move to the next state party. Floor back to you.
Muchas gracias.
I would like to thank the colleagues again for their input. Now let's move on to Hong Kong, China. The recommendations in paragraph 6 we'll deal with first, relating to effective guarantee of universal suffrage and the right to vote and to stand for election without restrictions of any kind. The state has given us different replies, information from a note from the state party in March of this year, telling us about some measures. And also in October, a few days ago, in fact, we received information on a consultation process that's ongoing and measures that are planned with a view to guaranteeing universal suffrage for the elections in 2016. It is stated that they don't find it necessary to make normative changes. The NGOs have also given us some information. And so the committee's evaluation, as in similar cases, is to give C1. We note the information, the replies from the state party, but we're going to ask more specific information as follow-up on the subject of implementation of effective measures and how the law will effectively meet the standards embodied in the covenant as regards political participation, the right to vote and to be elected. The second recommendation for Hong Kong relates to foreign domestic workers, and specifically many complaints that we considered admissible on discrimination, exploitation primarily of domestic migrant workers. And we had asked for specific information from the state. The state replies that the employment ordinance guarantees to these provides certain guarantees to these migrant workers and talks about how they resolve legal disputes that might arise, and also the implementation of a particular 2-week rule where a person has 2 weeks after the end of the employment contract to carry out the necessary procedures. We gave a recommendation of C1. They gave us some information, but not all the information that we requested. And we felt it was important that the state give us more precise information on how many cases of this type of abuse exist and how they're processed. On the subject of paragraph 22 now, also in connection with discrimination cases, we'd requested information from the state party regarding effective access of ethnic minorities to education without discrimination, and particularly the right to receive education in Chinese, which is important for integration. It provided information saying how much it is going to invest in this, the budget, for a program called Chinese Language Curriculum Second Language Learning Framework. So we, in this case, suggest B2 because the funding has been allocated for this activity. And we wanted to ask a little more about measures taken to more thoroughly integrate ethnic minorities in the public education system. We recommend sending a letter to the state party reflecting the analysis of the committee. Thank you, sir.
Thank you very much. Mr. Alveoli, the floor is open for the comments and questions. Mr. Flinterman, you have the floor.
Thank you very much, Mr. Chairman, and again, thanks to the rapporteurs for their proposals. And I must say, I agree with the analysis made by the rapporteurs on all the three issues, including also the issue of universal and equal suffrage. It's clear that the C1 grade is, I think, appropriate since we have received a response. But from the response, it appears that no actions have been taken that implement our recommendation. And the same is true, I think, for the recommendation on domestic migrant workers and migrant domestic workers. And my suggestion would be also taking into account the analysis of earlier states that in our letter reflecting the analysis of the committee, the recommendations on on universal and equal suffrage and on domestic workers should be reiterated. And in particular, of course, refer to that first sentence in the recommendation that Hong Kong, China should take all necessary measures to implement universal and equal suffrage in conformity with the covenant as a matter of priority for all future elections. My concrete proposal is to reflect the concrete recommendations, to reiterate the concrete recommendations in the letter of analysis to be sent to the state party.
Thank you very much, Mr. Flinterman. The next speaker is Madame Chanet. Madame Chanet, you have the floor.
Thank you, sir. I take the floor on the subject of follow-up on Hong Kong, because it seems to me that this report regarding the situation in Hong Kong shows some states and some large states who have contested the follow-up procedure, who have questions about it during the treaty body strengthening work. So here I think we have the evidence. NGOs and states reply, and within the deadlines, in this case. And it shows that this procedure is essential to demonstrate the link between the reports, so to not lose the thread. And it's particularly important for Hong Kong. There's the thread between the committee in Hong Kong, the state and civil society. And in this room, we have people who've been in touch with us for over 20 years. And this is because the covenant is the only international instrument on civil and political rights that protects a population. And so I think the committee should be particularly aware of this particular case while being fair. And it is for this reason that I support the proposal made by the rapporteurs, regarding the committee's evaluation. to be submitted to China, who will be receiving our letter. I agree with the evaluation. I don't entirely agree, however, with the terms of the evaluation in the report, the wording. I think we should be as precise in our evaluation as we are in our recommendation. And I mean the first recommendation regarding universal suffrage. We should talk about the right to vote and the right to be elected consistent with the covenant, and not refer to fundamental law. We didn't do this in the recommendation. I don't think we should do this because it's very complex. So we shouldn't use that language in the letter to the Chinese authorities. For the rest, I support this evaluation, and I think it is desirable to follow an approach that demonstrates that there's room for improvement through this dialogue with the committee. Thank you.
Thank you very much, Madam Chenet. And next speaker is Mr. Chenet.
Thank you, Mr. Chair. I'm in general agreement with the evaluation on all 3 points. I want, however, to make 2 proposals on the first recommendation dealing with the election issues. One pertaining to the language of the evaluation, where I would propose to the rapporteurs to add the following language to the second sentence of the evaluation, which describes the decision of 31 August, which did not require amending the basic law regarding the election methods for the CE and for LegCo. And I would propose adding the words, and which envisions a system where candidates for the position of CE would be vetted by a nominating committee not fully representative of the Hong Kong population. Because I think it's important to spell out what information we would be interested in reviewing. So this would be my first proposal, not to focus only on the amendment or the basic law, but also about the vetting system. And on the other proposal I have is to consider whether it wouldn't be advisable to divide the recommendation to 2 different elements. One pertaining to the right to vote, where I think there has been the measures which are proposed are moving in the right direction in terms of strengthening universal suffrage. But then the right to stand for election, where the measures proposed go directly against the recommendations of the committee. Currently, the fact that the 2 issues are being lumped together is rendering the dialogue, I think, more on the follow-up a little bit more difficult. So these would be my 2 comments. If this would be adopted, then we could also give 2 different rankings to these 2 different aspects of the recommendation. Thank you.
Thank you very much, Mr. Chenet. Before giving floor to next speaker, may I ask you to repeat your proposal? You suggested the language, which I think it will be useful for us to once again to hear the proposal.
Thank you, Chair. The language I propose adding after the words CE and for LegCo is, and which envisions a system where candidates for the position of CE would be vetted by a nominating committee not fully representative of the Hong Kong population.
Thank you very much. The next speaker is Ms. Dijberval. You have a floor.
Thank you very much, Mr. Chairman. I would like to follow up on what Mr. Savioli has already indicated. We have received in October updated information, as he pointed out, and there was reference to the National People's Congress Standing Committee's decision. This decision was adopted by the National People's Congress on 31st of October 2014. According to this decision, the election of the chief executive may be implemented by the method of universal suffrage in accordance with the Basic Law. We understand that this opens the way for an amendment of the Basic Law with respect to the right to vote, which still remains to be adopted. There is no information so far on the right to stand for elections. According to the information received by the Hong Kong Special Administrative Region, the NPCSC decision of 31st August sets out a clear framework on the specific methods for selecting the chief executive. But we missed the text so far of this decision and the concrete parameters of this method for selecting, so this has not been provided to us so far. To sum up, therefore, there is an ongoing constitutional reform process, the outcome of which we will see when we adopt our next report. So far, the action taken does not implement the recommendation adopted. But the Hong Kong Special Administrative Region informed us that it is the PRC's aspiration to implement universal suffrage for Hong Kong and with respect to the chief executive. And we will continue to observe this process. Therefore, I would like to turn to the recommendations made by our colleagues. I understand that the recommendation proposed by Madame Chanet was not to make reference to the Basic Law, and I think that there's a lot for these arguments to delete the reference and simply to state that the committee also noticed the decision of 31st August 2014, on the basis of which we are requiring further information. On the other hand, I can also see the need expressed by Mr. Chanet to obtain further information, not only with respect to the right to vote, but also with regard to the right to stand for election, as has been expressly observed by the committee in the concluding observations. Thank you.
Thank you very much, Ms. Zybert. I think you are basically in agreement with what Madame Chanet has proposed, and I think Mr. Flinterman had suggestions which will go in a similar terms, in similar lines. Mr. Ravioli, would you like to add anything on this point?
No mucho más.
Not really. I think Ms. Cyberford has given us an excellent summary of the state of play, and we'll be happy to add what Madame Chanet said and what Mr. Chani said and Mr. Flinterman's suggestion. I don't think anybody has any question with the rating, any problem with the rating, so or the ranking, so we'll incorporate those suggestions. Thank you.
Thank you very much, Ms. Salvioli. Then, there is another speaker requesting the floor. Ms. Majudina, you have a floor.
Yeah, I fully agree with all that has been said. It's just a quick question. Mm-hmm. I see that according to one NGO, there hasn't been any consideration of steps that will lead to the withdrawal of the reservation of Article 25B. I haven't had any opportunity to look this up, so I wonder if the rapporteurs have had the opportunity to consider this. Thank you.
There are two more speakers. I think Madame Chanet was first, and then Mr. Sidul Singh, and then I'll give floor to the rapporteur.
Oui, Monsieur le Président.
Thank you, sir. The UK government made a reservation. We need to go and look for it there. It was submitted by the British. it noted the history of the situation in terms of universal suffrage. So we always discuss the Hong Kong report. We always put forward Article 25 and for full respect of Article 25. And then in that context, we requested the withdrawal of the reservation. And so in our recommendation, we asked what steps had been taken in terms of withdrawing the reservation. So if you want to be comprehensive, since we're making an evaluation in which we say that there are still many issues before the authority responsible for the administration of Hong Kong and for the reform to guarantee the right to vote and the right to be elected, to stand for election, consistent with the covenant, with a view to withdrawing the reservation to Article 25B. So we could add that to the evaluation because the reply, they didn't even talk about this, but it was our recommendation. So we could continue along the lines of our evaluation by saying that this is all ultimately for the purpose of leading to the withdrawal of the reservation.
Thank you very much, Madam Shanem. Next speaker is Mr. Sital Singh.
Thank you, Chairman. I thank the rapporteurs for the report on Hong Kong. I have a question concerning the foreign domestic workers or domestic migrant workers concerning this live-in requirement. I see the position of the state is that this requirement is necessary to fill the shortfall of local live-in domestic workers in Hong Kong. And in our evaluation, we are asking if the state party envisages repealing this live-in requirement. I take it from the reply of the state party that it doesn't intend to abolish this live-in requirement. The clarification I want is whether the state is saying that this live-in requirement is in favor of domestic workers and imposes a burden on employers. I know that it leads to an abuse on the part of abusive employers who sometimes consider domestic workers to be at their service for 24 hours. But in this case, should we again ask if the state party envisages repealing the live-in requirement, or should we ask whether the domestic workers should be given an option to comply with this live-in requirement, and whether the immigration rules should be amended in that respect? I would like a clarification in that respect as to the exact reply of the state party. Thank you, Chairman.
Thank you very much. Thank you very much, Mr. Singh. I think I should rather prefer now to hand floor to Mr. Salvioli, so he would comment and respond both to the questions and to the comments made by the speakers, Madam Shanem, Mr. Majudina, and Mr. Sital Singh.
Thank you very much to colleagues for their input regarding the reservation mentioned by Madame Chanet. I think she also has explained that situation fully. The committee never felt that this reservation prevents us understanding effective implementation of Article 25 in terms of the right to vote and to be elected by universal suffrage. And so that's why the recommendation was couched in the terms it was when we, in our discussion with the state party, and now we want the state party to comply with the recommendation without touching on the matter of the reservation. We could add a paragraph saying that the state should provide information on measures taken to that end, but I don't think it's really necessary unless the committee considers otherwise. I would keep the text as it is by preference. On the subject of the situation of the migrant workers, the domestic migrant workers, we could ask the Secretariat perhaps if they have additional information. Is there any further information? I don't think there's much more than what already appears in the report. Thank you, sir.
Very much, Mr. Sarvioli. Secretariat has something to read out to us. You have a floor, Ms. Santana.
Thank you, Mr. Chair. I'm going to read the paragraph in which the state party refers to the living requirement. This is the submission that was submitted in March 2014. And in paragraph 13, the state part states that the living requirement forms the cornerstone of Hong Kong's policy of importing FDGs. As in many other jurisdictions, it has been the HKSAR government's established policy that priority in employment should be given to the local workforce, and importation of workers should only be allowed where there is proven manpower shortage in specific trades that cannot be filled by local workers. In accordance with this policy, FDHs have been imported since the early 1970s to meet the acute shortfall of local living domestic workers in Hong Kong. The HKSAR government considers it necessary to retain the living requirement for FDHs. Thank you, Mr. Chair.
Thank you very much, Ms. Santana. Now, before moving back to Mr. Salvioli, to the rapporteur, I should just probably say that it is my understanding that at this stage, while noting that there are consultations going on in Hong Kong, China regarding the issue of universal suffrage, the committee members are in agreement that there is a need to add a language into the evaluation part, which will underline the need to ensure universal suffrage, which means both to be elected as well as to have a right to vote. The main concerns were of the committee members were focused on the right to stand for elections without unreasonable restrictions. And with that, I would like to hand the floor back to the. But I think I'm sorry. There are before moving back to going back to the rapporteur. I would like to give floor first to Madame Chanet. I think you were taking the floor, and then there are no other speakers. And I assume we should sum up. Ms. Majudina. Okay, and I believe you will be the last speaker on this issue. You prefer to speak after them? Okay, Ms. Majudina, you have a floor.
Thank you, and I thank the rapporteurs. I won't be long. I just want to thank Ms. Chanet as well for clarifying the situation. But I think we should include a line on withdrawal of the reservation because to 27B, because it is at the heart of all that has been happening right up till now, all the consultations and the tensions between the state and the civil society of Hong Kong. So if we don't, I think it will just strengthen our recommendation if we would go back to what we said in earlier recommendations of the committee. Thank you.
Thank you very much, Ms. Majudina. Madame Chanet.
Merci, Monsieur.
Thank you, sir. I was ready to yield and say that it perhaps wasn't helpful, but now Madame Majudina has persuaded me that it might be a bit formal, but unless it seems as though we're going backwards, but I think we could incorporate our recommendation into the text. It's a logical sequence. In fact, in the recommendation, we said that we recommended, it's a specific recommendation, in fact, that measures, progressive measures be taken to move towards withdrawal of the reservation. So, since we can give an evolutionary suggestion, I think it wouldn't be out of place to just add here, with a view to ultimately withdrawing the reservation. It's not major, but perhaps it's worse not to say it than to say it. It might seem as though we'd given up on it if we don't mention it. It could be, and if it were to be interpreted like that, it would be a pity. It's just a question of interpretation.
Thank you very much, Madame Chanet. I would like to give floor back to the rapporteur, but I also have a question regarding the questions actually we sent to the state party, to Hong Kong, China. Did it include the questions? Did they include the reference to the issue of withdrawal? Thank you.
Gracias, señor.
Thank you, sir. In the recommendation, I would point out recommendation number 6 to the state party. It says that we recommend the possibility of considering measures leading to the withdrawal of the reservation. So it appears in the last part of our recommendation. And so in the light of the discussion, let me make a concrete proposal, which is as follows: that the state inform us about the measures taken with a view to withdrawing the reservation.
Could you repeat, please? Mr. Viole, could you please repeat the suggestion?
Sí.
Yes, that the state provide information about measures taken with a view to withdrawing the reservation consistent with the committee's recommendations.
Thank you very much, Mr. Salvioli. Measures taken, but we're also going to refer to the need to ensure universal suffrage, meaning both. Yes. That's in addition to that? Yes. Okay, thank you very much. Yes. It's clear for me. Ms. Seibert, you have the floor.
Thank you, Mr. Chair. I just would like to stress that the reservation doesn't have any kind of implication on what we are saying beforehand, because what we are saying beforehand, both with respect to the chief executive, the reservation is with respect to the Legislative Council. I think we should be very clear on that this doesn't diminish our calls and our proposals set up beforehand. And I would like also to remind the constant interpretation of the Human Rights Committee as spelled out by Madame Chanet with respect to the Legislative Council. There was that as soon as the Legislative Council has been created, the reservation would not apply anymore. But I don't object to the recommendation. I just wanted to make clear the meaning if we introduce this part there. I would also like to make a concrete suggestion with regard to the amendment in light of the discussion. So what I could get from the discussion so far, we would leave the committee's evaluation as it is, keep the first sentence, and then the second sentence should read: the committee also notes the decision of 31st August 2014 of the NPCSC, full stop. And then we would continue: the committee requires additional information on the specific method for selecting the CE and the LEC cow by universal suffrage, which includes the right to vote and the right to stand for election. Full stop.
Thank you very much, Ms. Zaibet. There is one more speaker, Mr. Sheni, you have the floor.
Sorry, I'm in full agreement with what has just been said, except that I would also retain the words and its compatibility with the covenant. I think it's important to leave the same. Thank you.
Yeah, I think there is an agreement on this regard, on this point as well. If there are no other speakers or no other members wishing to speak, then I again hand back floor to Mr. Savioli. I think we've heard all the suggestions, and we are in agreement with what should be there. And if there is no other suggestions, we may adopt the evaluation subject to the amendments and additions as they were proposed by the committee members. Floor is yours, Mr. Savioli.
Como usted señaló, señor presidente.
As you've said, sir, we've noted the proposals, they've been accepted, and they'll be reflected in the final text. Thank you to all colleagues for your input, and Ms. Cyberford, of course, thank you for giving all that additional information. Thank you.
Thank you very much. We now move to the next state party, and I would very much like to ask colleagues to be as brief as possible in presenting as well in the presentations as well as in the comments. We're very much behind the schedule, and of course I take a blame for that. But if you could help me, I would very much appreciate it. Mr. Violi, floor back is.
Muchas gracias, señor presidente.
Chair, thank you very much. It's not your fault. You obviously will not be blamed. It is us. It's up to us, and we will seek to help you as much as we can. So the first recommendation has to do with the reservation to Article 25 by Macau, that is. Macau, China. The state party told us that it is not going to follow the committee's recommendation. Hence, we reiterated our recommendation to the state party. Paragraph 11 had to do with providing legal assistance to persons on criminal matters. The state didn't give us concrete information on this matter beyond the dialogue that exists with continental China. So we've given a C1 rating to that. And the third recommendation that was selected for follow-up had to do with a recommendation on the placement agencies that take commission on non-resident workers, non-resident in Macau, on the issue of housing. And some NGOs have told us, or given us information on this, and we thought we could ask the state for more information. That's why we gave a B1 rating to the state's response. A B2, rather, says the interpreter, B2. Thank you very much, Mr. Chairman.
Thank you very much. Mr. Salvioli, any questions and comments on this issue? There are no questions, and in that case, I assume that we adopt the evaluation, and I invite the rapporteur to continue.
Muchas gracias, señor.
Thank you very much, Mr. Chairman. Moving on now to Angola. Angola is our last state party that we need to look at in this session, in this meeting. We'd asked Angola about the National Human Rights Institution. It does not comply fully with the Paris principles, this National Human Rights Institution. Therefore, we asked Angola for further information and their response has received a C1 category. With regards to domestic violence, that's para 10 of the concluding observations given to Angola by the committee. They attest to a number of measures, and specifically in the normative sphere, and they speak about a number of actions they have taken. In our view, these initiatives are positive. So we would like to expressly acknowledge those efforts explicitly, and we give them a B1 rating, though, at the same time, because we want to know more information as to how these issues are implemented. And if in the stats on domestic violence, domestic violence, we haven't received as much information, therefore we gave the response on domestic violence a B2 rating. As to measures of protection and prevention, there is a draft, a project on this, so we gave that response a C1 rating. And on the awareness-raising campaigns, the state didn't give us much information, and therefore we gave that response a C1 rating, pursuant to what they told us. On the last recommendation, paragraph 23, the committee will recall that there was a very sensitive issue linked to birth registration in the country. And on that, the state gave us information pertaining to initiatives that will run through to the 31st of December 2016. And we consider that their decision was extremely positive on the free registration of births, and for that we are giving an A rating, just to contradict those of you who said that teachers never gave top marks. But for the second part of that paragraph, we asked for additional information on the effective implementation of the recommendation, and we hope that this measure will continue to apply after the 31st of December 2016. We therefore recommend that we send a letter to the State Party in which we set forth our reasoning that led us to granting those ratings to this paragraph. Thank you very much, Mr. Chairman.
Thank you very much, Mr. Rioli. Are there any questions or comments? Colleagues seeking the floor? There are no such requests. With that, we adopt this part of the evaluation, and I think I again should hand floor back to the rapporteur.
Gracias.
Thank you, Mr. Chairman. This is the content of the report, the draft report. Some language versions, that is the French and the Spanish ones, will contain the analysis of another country. This analysis had been made, but once again, because of space restrictions, we weren't able to include that analysis of that country in the English version here. So we will deal with that country in the next session. So the work has been done by the Secretariat, by us as rapporteurs. And as I say, we will deal with that country in the next report. And next year, to solve this issue, we will submit 3 reports instead of 2, so that we can cover what we need to cover and cope with the very strict word limits imposed upon us. If I may, Mr. Chairman, to conclude, acknowledge the work carried out by the Secretariat, which has been sterling. Excellent work, and this is not a formal pronouncement. When things are done well, I really do want to record it, and when things are not done well, I'd like to record it as well. But in this particular case, the work has been outstanding, and to work with Ms. Zybert for also is, leaves me really at peace when it comes to analysis and everything else. It's been very comfortable, and it's been a pleasure to be able to report on this. Apologies for all the time we've taken, but the work we did was significant, sizable. So once again, thank you, Mr. Chairman. Thank you, colleagues.
Thank you very much, Mr. Alveoli. With that, we adopt a draft. We will adopt a follow-up report on concluding observations. I very much would like to thank the rapporteurs, Mr. Savioli and Ms. Seibert for the excellent work indeed, and obviously you proved to be a very strong team, and we're looking forward to the next follow-up reports to be considered. And obviously the thanks goes to the Secretariat. Thank you very much for your support. We are very much behind the schedule, and I would ask the committee members to forgive me for not giving a possibility of a break. I think we should continue suffering a little bit, and I will obviously suffer with all of you. And we'll let us move to the next item on the agenda, and let's try how far we'll go, and that is a follow-up progress report on individual communications. And the Special Rapporteur is Mr. Yosawa. Without any further ado, I would like to hand the floor to Mr. Yosawa. You have the floor, sir.
Thank you, Mr. Chairperson. I'm very pleased to introduce the progressive report, which was distributed to the members a few days ago. The report covers the follow-up submissions received and processed between March and July of this year. We had agreed in the 110th session that I would not prepare a report for July sessions, and following the practice of concluding observations, follow-up to concluding observations. I'm pleased to present you the progressive report in 3 working languages for the first time. I tried my best to have this report translated, and to achieve that objective, however, I had to make July the cut-off date for our analysis. The report includes some information submitted before March, but it is included because it was processed after between March and July. The submissions we received have been transmitted to the party, and transmission which took place after July are not indicated in the report, but will be indicate so in this report. And I ask the committee to leave it to me to make such indication in the report after we adopt the report. And I would like to remind the members that the report addresses only those cases on which we have received submissions from either the author or the state party. And this report also was prepared under the constraint of word limit. And I ask the committee members' understanding in this regard. For previous information, follow-up information we received, the report refers you to our annual reports. In the 109th session, we started to apply the follow-up criteria for concluding observations, also to state parties' submissions under the procedures for follow-up to views. The criteria are on the last page of the report, on the back. They may not be entirely satisfactory for our purposes, but we have continued to apply them on an experimental basis to state parties' submissions under follow-up procedures to views. We are not, I would like to remind the members that we are not assessing the status of the implementation of the views as such. We apply the criteria to state parties' submissions and assess the state parties' submissions on the implementation on the remedies. And I have tried to apply the criteria for each remedy we had requested wherever possible. With this introductory explanation, Mr. Chairperson, I'd like to proceed to the relevant sections, and I propose to adopt the relevant section on the state party to state party basis rather than case by case. Thank you.
Thank you very much, Mr. Yosawa. Are there any questions? Mr. Shani, you are taking the floor. You have the floor.
Thank you. I have 2 general questions to the rapporteur. One is really a technical question on the issue of or no information. Sometimes I think the words no information are used, and sometimes the letter D is used. And I was wondering whether this is deliberate or whether there are distinctions between different cases of failure to provide information. And secondly, and more perhaps significantly, the question is, do you envision any process by which some of the very lengthy cases that are pending, sometimes for 20 years, under what conditions will we be able to close them? Or maybe is it possible to also envision folding them into the periodic review where this is relevant, so that we would not have to revisit cases where nothing really is happening for many, many years? Thank you.
Thank you very much, Mr. Shalim. No others?
Thank you very much for the questions. I guess there have been some inconsistencies in indicating no information. In the future, we tried to be consistent. There was no specific reason for the distinction. As regard to some of the old cases, in the past few years, or several years, from my predecessors, the committee has adopted the policy of suspending follow-up procedures for cases in which the follow-up procedure does not serve the purpose. I have continued to maintain the practice, and I'm proposing closing some of the cases in this report also. In the periodic, in the consideration reports, we do have a paragraph in which we ask the state party to about the status of implementation. So we do both follow-up to views, and also we ask questions in the periodic report dialogue. Thank you.
Thank you very much, Mr. Yusawa. Any other questions? Mr. Rodriguez-Razzia, you have the floor.
Mr. Iwasawa, thank you very much for your report. I would like to refer to the point of the criteria you're proposing for us to adopt, and I would like to reopen that debate on the old cases where the state has not abided by our recommendations. Now, for that, this is a very tedious issue, very difficult task, and complicated. It's complicated to send a message to the states who do not abide by our recommendations, who are indifferent. If we tell them that if we leave this, let it sleep, one day they will be relinquished of their responsibilities. Now, I understand the decision, but I think we should seek another way of dealing with old cases and not allow the states to get away with it by just allowing these cases to lie dormant and then to fall off the edge. Now, could we have a list of these appeals to draw attention to these cases, but let us not take them out of the list of cases that are still pending and that still haven't been abided by?
Thank you very much, Mr. Rodriguez-Razzia. Before handing to Mr. Iwasawa, I would also like to ask the members of the committee to come up with some suggestions. If there are, obviously, we're all concerned with the fact, but Mr. Iwasawa mentioned that in a way this issue will come up in the reports. It will come up then in concluding observations. It may also come up in a follow-up with the concluding observations. But if there's anything else we can do, because you're absolutely right that the state party should not be satisfied that in case if they keep silent for a long time, then the issue will just disappear at one point. I think Secretariat had something to add on that point, and I'm happy to give the floor to Mr. Petro.
Thank you, Chair. I just wanted to share with you what CEDAW does. CEDAW, when they decide to close cases in similar situations, they close the dialogue they close the dialogue regarding the individual cases follow-up procedure, but with the decision that they will continue, everything which relates to follow-up to this case will continue in the framework of the reporting procedure, but the state party is informed officially of this decision. There is a note verbal that it's sent. So like that they know that it's, and we still keep track of it.
Thank you very much, Mr. Petrov. Mr. Ruiz, you have the floor.
Well, I'm a bit concerned about the time. We are going into a working method discussion. We do have a list. In the annual report, we list cases. And even if we suspend the follow-up dialogue, we indicate in the list no unsatisfactory implementation. So there is an indication in the annual report that the case, the views has not been implemented, even if we suspend the follow-up dialogue. We suspend the follow-up dialogue because the follow-up dialogue is keeping the case on the follow-up procedure doesn't really serve the purpose. Thank you.
Thank you very much. Yes, I think we should draw to the close the discussions on that issue. We can probably hardly make any changes at this point, but the problem is noted, and I think we should, as Mr. Yosawa mentioned, we should come back to that during discussions on the working methods. Mr. Yosawa, you have a floor to present the report state by state as you suggested.
Thank you. Azerbaijan, case number 1633. The remedies we asked, investigation, prosecution, compensation. We received submission from the author that his case remains unanswered. Proposed decision, follow-up dialogue ongoing. Thank you.
Thank you very much. Mr. Yosawa, any questions? Then we move to the next party, which is Bosnia-Herzegovina.
Bosnia-Herzegovina, case number 1917, 18, 25, 53 together. This is an enforced disappearance case. The remedies we asked to continue efforts to establish the fate or whereabouts of their relatives, bring to justice those responsible, abolish the obligation for many family members to declare their missing relatives dead to benefit from social allowances and compensation. We received a lengthy submission from the state party. I only highlight some of the important parts. 2 criminal cases ongoing against the suspect allegedly involved in the enforced disappearance. The committee's view, according to the state party, views are considered as binding for the Missing Persons Institute. And following a request that newborn samples be taken from all mortal remains, an order was immediately issued. And according to the state party, compensation issues are solved by establishing a special fund, but this is not yet operational. And the views were translated and published on the Ministry of Human Rights website. And also, a provision was deleted in the draft law on amendments to the law on the rights of veterans and members of their families, removing the obligation of families of disappeared persons to declare them dead in order to be eligible for social benefits. This is still a draft. So the proposed assessment, A, B, C, D, E, and F, efforts to establish the fate or whereabouts of the author's relative, B2, efforts to bring to justice those responsible, B2, abolish the obligation for family members to declare their missing relatives dead to benefit from social allowances, B1, ensuring the adequate compensation, C1, publication of the views, A, non-repetition, B1, and the proposed decision, follow-up dialogue ongoing. The second case on Bosnia, the same state party, case number 1955. It's a case on violations of Article 9, 17, and 23. Should the author be removed to Iraq? And the remedy we asked, either release the author on appropriate conditions or provide him with an opportunity to challenge grounds on which his detention is based. and also full reconsideration of the reasons for removing the author to Iraq. The author submitted that the government considers that the legal effect of the interim measures has terminated and measures to deport the author are actively taken. Therefore, I refer you to footnote number 1. The committee, acting through its chairperson, addressed a letter to the state party in March, but the deportation proceedings are continuing. And also, according to the state party, views were translated and disseminated and published on its website. According to the state party, the appellate panel ordered that the Service for Foreign Affairs should reinstate proceedings in light of the views. And the Service for Foreigners Affairs reviewed the case and requested a new security assessment. And the Intelligence and Security Agency submitted that the author still constituted a threat to national security. An appeal was filed by the author before the Constitutional Court, and it remains pending. But it is important to note that I refer you to page 6 of a submission from the author. The author was released from detention in May. So proposed assessment, compensation, no information, release, or adequate opportunity to challenge grounds on which his detention is based, B1, full reconsideration of the reasons for removal to Iraq, C1, publication of the views, A, and proposed decision, follow-up dialogue ongoing. Thank you.
Thank you very much, Mr. Izawa. Any questions, comments? Any colleagues wishing to intervene? There are no questions, so Mr. Izawa, you have the floor.
Thank you. Next state party, Cameroon. I will talk about the follow-up meeting that I have had with representatives of state parties, but I had a follow-up meeting with the representative of Cameroon in March, and as a result, in June, we received follow-up submissions from Cameroon on all the cases pending. That was a very good result of the meeting, follow-up meeting that I had in March. So I start with the case 458. This is a very old case, views adopted in 1994. The remedy we asked, compensation, investigation of allegations of ill treatment, and to respect his right under Article 19. State party says a compensation of 100 million CFA francs, around 152,000 euros, was offered to the author. So this submission was transmitted to the author. There's no indication, but it wasn't transmitted to the author and waiting for the author's response. The committee's assessment, compensation B2, investigation D1, respect for the author's right under Article 19, no information, publication of the views, no information, and proposed decision, follow-up dialogue ongoing. Next case, 1134, violations of 9, 10, 12, 25, remedies we asked, compensation, assurance of the enjoyment of his civil and political rights. According to the state party, an agreement with the author was reached and measures are underway to offer him a compensation of 40 million CFA francs. Committee's assessment, proposed assessment, compensation B1, assurance of the author's enjoyment of his civil and political rights, no information, publication of views, no information, proposed decision, follow-up dialogue ongoing. Next case on the same state party, 1186. Remedies we asked, compensation, institution of criminal proceedings against all those responsible, According to the state party, contacts have been initiated with a view to offering compensation to the author. Proposed assessment, compensation B2, institution of criminal proceedings, no information, publication of the views, no information, proposed decision, follow-up dialogue ongoing. Next case with regard to the same state party, 1353. Remedies requested, prompt prosecution and conviction of the persons responsible, protection from threats and intimidation, and compensation. I refer you to the state party submission first. Investigation have proved to be very difficult to conduct because of the lapse of time. It's a very old case. And regarding the compensation, according to the I refer you to the submission by the author. Sorry, I talk about the compensation first. According to the state party, 20 million CFA franc compensation offer was made to the author. But the author each year since 2010, this author has rejected. And according to the author, I refer you to the submission by the council. The offer is insufficient, according to the council. The author's initial request of 500 million CFA franc, approximately 760,000 euros, is maintained. As the state party says, it is unable to accede to this author's original request. And according to the state party, should the author decline its offer, again, the case should be closed. Proposed assessment, criminal prosecution C1, protection from threats and intimidation, not applicable because the author has left the country. Compensation B2, publication of the views C1, non-repetition B2. Follow-up dialogue ongoing, but we note that the state party insists that should the author decline its offer, the case should be closed. The next case with the same state party, case 1397. The author remedies requested, the author's immediate release, ophthalmological treatment, and according to the state party, the author could not be released after having served his 10-year prison sentence because of 5 other judicial proceedings pending against him, and because he could abscond. And the state party says, accordingly, the first part of the remedy cannot be implemented, and the author was provided access to an ophthalmologist. Proposed decision, follow-up dialogue ongoing. Cameroon, the next case, 1813. Remedy, a review of his conviction, investigation and prosecution, compensation. State party is willing to implement the committee's recommendation, state party says. New proceedings can be initiated as soon as the author appeals its judgment. And once the author files a complaint for torture and ill treatment, an investigation will be undertaken. The author has escaped from prison, and arrest warrant was issued against him. And the above procedures will only be opened once the arrest warrant against him is executed. And with regard to compensation, compensation may be awarded based on the result of the investigations. So the proposed assessment, review of conviction, C2, investigation and prosecution, C2, publication of views, no information. Proposed decision, follow-up dialogue ongoing. Thank you very much, Mr. Chair.
Thank you very much, Mr. Yasawa. Any questions or comments on that? There are two speakers. Who was the first? Mr. Shani was the. I think Mr. Shani wants to intervene later on. Did I understand you correctly?
Thank you, Mr. Chair. I was trying to be courteous, but I see it's complicating the matter. So I'll just say what I have. I forgot to say before, but I should congratulate the rapporteur for a very, very good and well-structured report. I have two questions. One on the very last case, on the case in which the person has escaped, 1813. And I was wondering why on the review of conviction it's a C2 and not either NA or even A, because the state is saying that once he returns, we will consider. But now he's not available. He's literally not available. So I thought maybe that judgment was too harsh. And on the other interesting case 1353, where the state is offering money and the author is saying this is not enough money, I wonder what basis do we have to decide between B2 and B1? How can we assess whether this is for the harm incurred and for the cost of living or what have you? How can we? I find it a bit difficult to just to use the consent of the author as the sole indicator for whether full compliance has been achieved or not with the recommendation. Thank you.
Thank you very much, Mr. Shani. Mr. Newman, the next speaker. Mr. Newman, have the floor.
Thank you, Mr. Chair. With regard to the 1353 Afusan case, I wanted to ask about the statement on page 9 by the state party that the fact that the committee did not indicate a quantum of compensation clearly suggests that the amount is left to the discretion of the state. I just wanted to ask whether in the follow-up dialogue that misunderstanding on the part of the state is going to be corrected, what the proposal is to deal with that statement. Since I got to go second, I just want to comment with regard to the Kwanga case where the author has escaped. I do remember that case, and I do not think that A would be an appropriate grade in this case. So I'm entirely with the rapporteur, and I also agree with the praise of the report. Thank you.
Thank you very much, Mr. Newman. Mr. Fatala is the next speaker on my list. Mr.
Thank you, Mr. Chairman. Mr. Chairman, concerning the case 1813, I believe that I can support the proposal of Mr. Shani, or at least not to have for the review of the conviction C2, at least to have it B, and if not A, because he escaped, and we got a very positive reply from the Cameroon concerning his case. Thank you, Mr. Chair.
Thank you very much. Mr. Yasawa, would you like to react to
that? Yeah, thank you very much. When I met the representative of the state party in March, we discussed about the amount of compensation. And we pointed out that it's not at the discretion of the state party, but on the other hand, we only ask for effective remedy. We don't specify the amount. With regard to case number 1353, there is an issue. They disagree on the amount. And the state party insists that if the author declines its offer, the case should be closed. For the moment, what grade do we give? Well, it's up to the committee, I guess, to assess whether the compensation the state party offered is sufficient. And I propose B2, but if committee would like to change to B1, it's up to the committee. With regard to 1813, I take the point by Mr. Shani, where it's also up to the committee if they would like to change this to not applicable, right? N/A, if the committee wants. Thank you.
The next speaker is Mr. Rodriguez Racia. You have the floor.
No,
In that, regarding the absconded prisoner, I agree with Mr. Newman. The fact that the person has absconded, escaped, and hasn't picked up the money doesn't mean that the case is finished. Here, there's a discussion about this. I have information that I'd like to confirm it over lunchtime, whether if there's a danger he might be picked up if he tries to collect the compensation. So I don't think we can put an A. It's difficult. I would put A when all the parties are satisfied and have complied. I agree with what the rapporteur has suggested.
Okay, Mr. Yosawa.
Well, in view of the time, I propose that we keep the report as is, and I would like to proceed to the next stage part, if I may.
Yeah, there are differences of opinions among the committee members on the issue. I'm not sure if we can. May I invite those who wish to make changes to the proposed evaluation to signal their position again. Mr. Chenier.
Thank you. I think the NA, the non-available, I think people were concerned, some of the speakers were concerned with the A, which perhaps is too radical of a proposal, but I think an NA under the circumstances with of course, the 1813 case, I think this is something that is more appropriate. But again, this is for the committee to decide.
Thank you, Mr. Chenier. Mr. Newman, you have the floor.
Thank you, Mr. Chair. We found that the author was tortured in detention. He escaped. He had been given an unfair trial. All of that happened before we decided the case. They're now saying if he's going to surrender and come back, then we'll reconsider his conviction. I don't think that's compliance with the remedy that we ordered. So I don't see why we should be doing anything other than what the rapporteur is doing here. Thank you.
Thank you very much, Mr. Newman. Your arguments sound convincing to me. But Mr. Chenier again seeks floor, so I give the floor to Mr. Chenier.
Thank you. I have sympathy for this position, but if the author is not present, I don't see how a retrial can be held. It's simply we shouldn't be demanding from states to attain the impossible. So that's why I think an NA, not relevant or not available, is a more adequate because of the unique circumstances of the case than making a judgment which essentially indicated they have not provided information about. They've provided information that they cannot hold a trial in the absence of the accused.
Okay. Could there have been any measures the state could have taken without the author present? My understanding that the state party refers that in a way it is for them it is impossible to do anything in that circumstances. Mr. Yosawa, any additional comments and thoughts on this issue?
I still maintain my original position.
You are.
I think Mr. Newman helped me. Thank you.
Okay. Unless Mr. Chenier is pressing on the issue, then I think we should continue with evaluation as suggested by the rapporteur and move on. So
Canada.
We adopt this part of the report, of the draft report.
Okay,
Mr.
Canada, case number 1881, violation was 6 and 7. Should the author be deported to Pakistan? and remedy requested, full reconsideration of his claim regarding the risk. According to the state party authors, application for a permission to stay on humanitarian and compassionate grounds, H&C application, was approved in principle. And provided that he is granted permanent resident status, the author will not be subject to removal from Canada. Proposal assessment, remedy A, publication of the views, no information. And proposed decision, follow-up dialogue ongoing, pending receipt of the confirmation that the agency application was approved. Next case, 1898, violations of Articles 6 and 7, should the author be deported to Pakistan. Remedy requested, full reconsideration of the author's claim regarding the risk. According to the state party, the author's H&C application is still under consideration, and the committee's views will be taken into account. Proposed assessment, remedy B1, publication of the views, no information. Proposed decision, follow-up dialogue ongoing. The next case, 1912, violation of 7, should the author be returned to Sri Lanka. Requested remedy, full reconsideration of the author's claim regarding the risk. According to the state party, the requisite background checks related to the author's H&C application are still underway, but process is underway. The proposed assessment, remedy A, publication of the views, no information. Proposed decision, follow-up dialogue ongoing, pending, again, receipt of confirmation that the author's H&C application was approved. Next case, 1959, violations of 6, 7, 17, 23, should the author be returned to Somalia. And remedy, refrain from reporting him to Somalia. The state party says the author was removed in February 2012 to Mogadishu on his way to northern Somalia. And while in transit at the Amsterdam airport, he expressed the wish to apply for asylum in the Netherlands. But the author's asylum application in the Netherlands was rejected. Proposed assessment, remedy E, he was deported. Publication of the views, no information. And I propose the committee decision, follow-up dialogue ongoing. And I add, the state party should ensure diplomatic follow-up and regularly report to the committee on the author's whereabouts. I stop here. Thank you.
Thank you very much, Mr. Rezawa. Any questions, comments? Mr. Shini, you have the floor.
Thank you. I have a question on one word which is used in the decision, both with respect to the first case, 1881, and also with respect to the third case, 1912. And this is that we, pending receipt of the confirmation that the HC application was approved. I'm concerned about the word approved, because this seems to suggest that the remedy by necessity means no a decision after reconsideration to reach a certain outcome. And I think that the remedy was to have a full reconsideration in light of the consideration, but I don't think our remedy insisted on an outcome of that process. So I am directing the attention of the rapporteur to the laden significance of the word approve in this context.
Thank you very much, Mr. Shini.
The point has been taken, but this, well, we continue the follow-up dialogue. But if the permanent residence is granted, maybe in the next session, we can suspend, or maybe we can close the follow-up. In order to flag this possibility, I added this pending part. But the point has been taken. Thank you.
So suggestion is now to just to seek the further information and to close. Well, Mr. Rezawa, could you please repeat what would be your final view on that?
I like to keep the pending part, but maybe we can adjust the language. Pending receipt of the information on his, yeah, okay, that's that.
On the out.
Okay, understand. Okay, fine. Anybody else who wish to add comment on that? No, I think that was subject to the proposal made by Mr. Cheny. We can adopt that part of the report and then move to the next state party, which is Democratic Republic of Congo.
Thank you. The Democratic Republic of the Congo. The first case is very old. Case number 16, views adopted in 1983. Requested remedy compensation. The author submitted follow-up information this year. He says, despite all the legal procedure initiated, no decision was adopted with respect to the draft decree on restitution of the author's confiscated property. Proposed decision, follow-up dialogue ongoing. Next case, 641. Remedy requested, effective reinstatement to public service and compensation. According to the author, the state party still refuses to provide the author with an effective remedy. Proposed dialogue, follow-up dialogue ongoing. By the way, I met the representative of the DRC this session. It was long overdue, and the DRC has not submitted any follow-up information on any of the cases. But the discussion I had with the representative of the state party was positive, and they are willing to cooperate with us. Thank you.
Thank you very much, Mr. Yosawa. No, are there any questions? May I ask the rapporteur just to focus on probably on additional information or any specific issues which he wants to flag to the committee, or otherwise just make a very brief comments so we could go a bit faster in the time left.
Okay, I'll try my best. With regard to the next party, next state party, we have 1, 2, 3 cases. We didn't receive much, and therefore, for the first case, 1620, proposed assessment, remedy C1, and for publication of the views, I would like to correct my proposal. For the publication of the views, with regard to all 3 cases, I'd like to change it to C2, and I refer you to the last case on page 16 in the English version. There is a footnote number 4. This state party maintains that dissemination of the committee's views are not necessary because it's already guaranteed by the publication of the views on our website in French. Therefore, I propose that we give C2 to every case, and I modify my proposal in this regard. For the second case, committee's assessment, same remedy, C1. The third case, 1928, this is the case on the freedom of religion, about the passport. The same proposal, assessment, remedy, C1, and non-repetition, C2. Thank you.
Thank you very much, Mr. Yosawa. Any questions or comments from the committee members? No. Well, in the light of the time left, actually, there is no time left. It's 1 o'clock. I assume that I have to suspend the meeting and suspend the consideration of this draft report in a consultation with the chair, in a consultation chair of the committee, in a consultation with the members. Probably will make a decision when we will continue with the consideration. At this stage, unfortunately, we have to stop where we are now and continue from that point whenever we'll give a possibility.
Can we continue with the follow-up report at 3? No.
Okay, at 3 o'clock we will resume the session with considering the general comment on number 35. At this stage, I suspend the meeting, and I want to thank very much the members of the committee for their hard work, and I want to thank the interpreters for allowing us to work without a break, and sorry for the sufferings which that caused to all of us. With that, session is suspended.